You're welcome back. And before I do your text messages, to remind you that the 30th anniversary of Star Assurance is ongoing, and you know that they are doing creating smiles, and that's what they've been doing since 1985. Just call them on 030-224-0632. That's 030-224-0632, and discover the solid insurance experience all year round for you. If it's about customers, if it's about risk, it's about fire and other allied perils that you want insurance to cover, the best place to go is Star Assurance. Sasso spray kills mosquitoes, cockroaches, houseflies, ants, and other crawling and fly insects. Sasso mosquito coil is smokeless. Sasso spray leaves a sweet lemon fragrance in your room till the next day. Sasso mosquito coil and spray is free from catarrh, headaches, and chest infections. Insist on Sasso mosquito coil whenever you visit a shop to buy an insecticide spray. Sasso mosquito coil and spray, the best on the market. And every day we make countless decisions, but what is your major concern? If it is to send and receive money safely, then let me tell you about a convenient banking experience, and that is with Bank of Africa, Ghana. They have the money transfer products for you, and they are very swift. So you can do money transfers at Bank of Africa via Western Union, via MoneyGram, and via Wari. Bank on the go with their electronic banking products, that is B-Web and B-Mobile. I'm saying go, be on the go as you do all of these things, and you feel very convenient about them. And also pay your utility bills and fees at Bank of Africa. That's value for your time. And MTN, do you desperately need the contact of that hotel or fast food joint? You need to know the nearest hospital or bank, or do you want your business to reach millions of potential customers? It's very simple. You dial star 1188 hash, star 1188 hash, or call that same number and get all the contacts you need from MTN 1188 directory service. You can also download the 1188 directory service app on the MTN and Google Play stores today. Get real-time information on service providers or register your business and get found by millions of customers. Step into the new world with MTN 1188 directory services. MTN Business, welcome to the new world. Now, let's take some of your messages. And Kofi Atta in Cambridge, in the UK, says GBA has had two representatives on the Judicial Council, and so should be privy to the judicial appointments under Article 144 have been made since the Fourth Republic. The assertion that the suit is for the future is untenable and disingenuous. Moreover, the language of the four reliefs being sought is an attempt to rewrite the 1992 Constitution, an unconstitutional act, as that right is reserved for Parliament. Adam in London says asset declaration is just like publishing the CV of public office holders before vetting. So why are they hiding in sealed envelopes? Simon says that the legitimate concerns raised by the NPP, okay, I think we have dealt with this earlier. Thank you very much for these messages. And right, yes, you're still here, and the show is coming to you live from the Multi TV studios. It is also live on Joy 99.7 FM, on Love FM in Kumasi, and over a dozen affiliate stations across the country. Also, all over the world, you may be watching us now on MultiTV World/streams, or you are watching us listening to us on myjoyonline.com. Thank you very much. Now, let's deal with the sole commissioner for judgment debts. You know that sometime on the 8th day of October 2012, the president inaugurated the commission, that is Justice Apau's commission, and gave it the mandate to do three major things. Number one, to ascertain the cause of any inordinate payments made from public funds in satisfaction of judgment debts since the coming into force of the 1992 Constitution, including debts arising from arbitration awards, negotiated settlements, and akin matters. Two, ascertain whether any financial losses against the state arose thereby, any financial losses arose thereby. And three, to make recommendations to government for ensuring that, one, as much as possible, such incidents of unnecessary judgment debts payments are avoided, and two, that the government does not incur unnecessary or undue losses when it does business through its agents and or through its offices. Well, there's been a leaked report of the commission's work after the commission was done and submitted same. And you have seen a serialization of that report on various news platforms. It's out of control. You can't do anything about it. Just like the YFK person. Okay. Now, the commission has done its work and it made some observations. I just want to mention some of the observations it's made. Judgment debts arising out of contractual breaches by the government and its agencies, MMDAs, and so on. And it outlines that that's how some of them came about. Some of the judgment debts also arose out of the failure on the part of the government to promptly pay compensations in respect of compulsory land acquisitions made by the state. Another was that judgment debts arising out of tortious or statutory breaches by public officials in the course of their official duties. That is where the police, the IGP says now, if the police bring those debts, they will be personally liable for them and not the state or the police institution. Now, these are some of the findings, broadly speaking, that the commission identified some of the factors that account for unwarranted payments, judgment debts, huge compensation for compulsorily acquired state lands. These are some of the failures they identified. One, failure to execute a comprehensive and systematic title registration throughout Ghana. Poor record keeping and improper correlation of records. Lackadaisical attitude of some law officers at the Attorney General's office in the handling of civil suits against the state, i.e. non-representation of the state at the courts. They account for most of the situation so that the people get a default judgment and then they come and get the money. Non-response from MDAs to notices of intention to sue. It happens a lot, and I can tell you from experience. You write to them and they don't bother. Then you sue. You get your judgments and then you go against them. Lack of patriotism on the part of many public officers. Political pressures from landowners. Inability of governments to use acquired lands and failure to make prompt payments for government-acquired lands. Honorable Yunus Afuseni can tell you a lot about that. Yeah, lack of documentation on lands by landowners. Non-identification of talents by governments due to political considerations. Very soon you come to understand what it means by non-identification of talents. So that we engage external solicitors and we spend a lot of money on them when you can get some in Ghana. Well, that goes to my benefit, so if it is properly done. Failure on the part of state institutions to adhere to laid down procedures. And finally, total breakdown of discipline due to institutional failures. Now we are going to pay attention to only two of the recommendations, of the findings and the recommendations. And these two are in respect of the payment of over 51 million to Woyome and the payment of $19.5 million. The first one, Woyome, is Ghana cedis. The second one is $1 million to Societe Generale. And what happened to the balance of $3.5 million from the sale of GMPC's drill ship, Discoverer 155, is it? 511, which was sold for 24, and 19.5 was taken out of that to pay, and then 3.5 was put in a certain account, and then about 1 million was supposed to have been given to the lawyers who were supposed to take 100,000 for their fees and then use the rest to pay other subsequent debts owned by GMPC. Now, I'll start with you.
Okay.
In your reading of the payment, particularly to Woyome, you find that Justice Apao has simply confirmed what we have known over the period, what Ioko told the whole world, what the Supreme Court said twice in this payment, and the discoveries that came out of the High Court process, as far as Justice Ajati Nasam's judgment is concerned. What do you make of the findings?
Well, I think that basically the findings are what commissions of inquiry are supposed to get us to understand. I mean, they are instruments that enable us to learn and understand the manifestations of corruption, the mechanics behind those who perpetrate corruption, and then the wasteful consequences on the economy.
Right.
I mean, this clearly why we set up commissions of inquiry. I mean, there's a huge relationship between the corruption manifested in the issues that you have raised, non-compliance with statutory obligations, or tortious acts of public officers, non-payment of compensation, and then the subsequent evaluation and payment of compensation for non-existent claims, the breach of contract, and the re-award of those contracts manifest themselves in corrupt practices, and they have a direct relationship with the problems of any economy at all. So that is why we set up commissions of inquiry, and they have been around since Nkrumah was president of this country. So yes, what the commission of inquiry has done in the case of Woyome is to get us to understand exactly the sequence of events.
The commission reaffirms that Woyome was simply not deserving, and it actually quotes Justice Jones Doshe that any due diligence, the slightest due diligence on the part of any lawyer and on the part of the lawyers of the state would have brought that revelation to bear. So Woyome would not have been entitled to anything. But the other aspect which he also gives a lot of emphasis on is to take on the judge who granted the default judgment, because he says that Woyome amended his statement of claim twice. He amended the first time, which you are allowed by law to amend without leave of the court. Then he amended a second time, which he needed leave of the court and didn't go for. And that, even that, after the amendment, he ought to have waited for 14 days. If the Attorney General had not replied, then he could have gone for the default judgment. He waited for only 7 days or less and went to the court and still got a default judgment.
My brother, he did not even go to the court. The day that the default judgment was taken, he was not in court.
Yes, he was only his lawyer.
He was only his lawyer.
Right.
And the Attorney General was not in court.
Right.
And the default judgment was granted. You know, so I've read that section too, and I say, wow, I mean, this clearly, I mean, and that is why we have the Judicial Council in place, and they should play more advisory and supervisory role.
He takes on his own colleague whom he sits with in the Court of Appeal. Now he's moved to Supreme Court. So he takes on his own colleague, but he didn't do a thorough job, just like the Supreme Court hinted earlier.
And I think that our justices must be proactive and not behave like timorous souls. Okay, and when issues of state resources are involved, they compel the appearance of the Attorney General's office. I mean, they ought to do that, because the money doesn't belong to the Attorney General. It doesn't belong to the politician. It belongs also to the judge who is presiding over the case, because his taxes come together to aggregate the monies that are going to be used to be paid.
Right.
And so when our judges become proactive and demand the appearance of officers and legal personnel at the Attorney General's office, then we might be able to stem the tide of these inordinate payments that are being made by reason of these breaches, whether they be a breach of a contract or a statutory provision or a failure to pay compensation. So I think that basically, like I said, for me, this is an important finding. I mean, commissions of inquiries are find facts, the fact-finding commissions, and it's found the facts. And we ought to see how, going forward, we can use the facts so found to improve upon the administration and management of the public purse. And that is what we should do. And where, as in the case of the Judgement Committee, where their terms of reference did not include going behind to investigate further to come to certain conclusions, the government should take it up through a white paper and do the investigation. I mean, that might serve to bring people, probably based on that second investigation, to account for their actions in court.
I see. Very interesting. Now, Tony, you also have him make certain suggestions. He says, first of all, that the default judgment was given in error on the face of the record. But we know that the first rate he had issued, the original rate, the Attorney General did not defend. And the Attorney General subsequently went to court and said, we know we don't have a defense anyway. Yeah. So is the judge to blame in this matter?
Not to personalize the issue, the judge happens to be my very, very good friend. However, when this matter happened, I was not in Ghana.
Okay.
When I came, I took issue with the judge, not personally, but my view, as Honorable has just said, was that if you look at the quantum of the particular matter, I don't think the judge ought to have acted as a robot. Because even for now, when I file an application for judgment in default of either appearance or defense, I try to justify why the judge should give me judgment. So that at least the judge will be satisfied in his mind that these are the reasons, not just because time has lapsed. So in a matter of this nature, I would tend to agree with Honorable that there must have been more investigation. And some of these findings should have been apparent to the judge, who is extremely competent.
But do you also find that the Second Amendment, I understand, was to the rate and not the statement?
Not to the statement of claim. Yes.
So does it make any difference in what the judge calls premature default judgment?
Of course it does. Because then the other side will have to have the opportunity to respond. Because it goes to the substance of it, not the explanation of the substance is the rate and the explanation is the statement of claim.
So we put the burden on the judge.
I will agree.
The AG's department are our lawyers.
Yes.
They were supposed to go to court, and you would have done this very easily. You know, you would have shut your eyes and throw this default judgment out. So why did they not do it?
Samson, by my position at the Ghana Bar Association, I'm supposed to defend the legal profession. It's difficult in this particular instance. But if you look at the information that you sent to us, if you look at the reminder in the Ekafco Furniture Limited case, there are several instances, and on our tours to the regions, that Attorney General's Department has told us, when they have been castigated by judges, that sometimes they don't even have the information to go to court at all. They go to court, seek adjournments, and if you look at this letter by one Mrs. Pelakumi Srebo, several reminders have been sent to the government agency, and the Attorney General does not have the facts to file a defense. Why do we tend to blame them? Because they are as competent as we are. But if they don't have the tools with which to file the processes, and remember, the time does not wait for the Attorney General's Department. So unfortunately, some of the castigations against the Attorney General's Department must be measured in view of the difficulties that they have. There seems to be no coordination between the ministries and the chief legal advisor. And these also lead to judgment debts. And this is something that has not been highlighted.
Interesting. Kuku is going through. It looks like an official copy.
Now, since
It's been leaked and bound.
since Malik popularized the saying that he had intercepted the report,
yes.
they have not become acceptable.
He's a chief interceptor of documents, official documents.
This one was delivered.
Oh, really?
Not intercepted.
Okay.
The way, yeah, you cannot intercept this.
Okay.
Because it's a finished product.
Okay.
And usually the interception happens when it's in transit to
right.
the destination. So you intercept, you make a copy, and you allow the original to proceed.
And look at me ignorantly sending him a copy of what I had.
Yes, you did. You did send me a copy.
Yeah, so what do you make of the aspects of the Woyomi payment?
The Woyomi thing, I think I have to choose my words carefully. But for the critique of a fellow judge, which indeed, even in substance, the Supreme Court had already done. And the reference to the Iwoku report, which surprises me, because did you ever see a final report?
We still are waiting for the final report.
Yes.
It's still an interim report.
Otherwise, I would suggest respectfully that the Woyomi chapter here is a cut and paste one. It's a cut and paste. There is nothing new there.
Okay.
For public perusal. I don't know whether I've sounded offensive. That's the way I see it. So really, we have exhausted the commentary on the Woyomi thing.
But he makes a curious finding that we may not have paid attention all this while. He says that the monies that Woyomi was demanding, later on when he amended his rate, a casual reading will show that what he was asking for himself alone, he says this: the commission is minded to pose this question because Woyomi as plaintiff had pleaded that, let me read it in full. Going by Alfred Woyomi's own pleaded case, the question that readily comes to mind is, why would the then Attorney General, Mrs. Betty Moldudrisu, order that Woyomi be paid the cedi equivalent of 22,501.74 euro for his alleged financial engineering cost alone. The commission is minded to pose this question because Woyomi as a plaintiff had pleaded that the total value of works actually done by his company, Waterville, plus his 2% financial engineering cost, which Waterville claimed from the government of Ghana, was 32 million euros in all. So why should Woyomi's 2% be bigger than what he was actually paid to his principals, Waterville, for works alleged to have been actually done?
Well, I'm not sure if Woyomi ever claimed that Waterville was his company. I don't recall that. And you see, these issues have been raised already, interrogated.
No, but it's curious.
No,
he's saying
no,
we should have seen this from the beginning.
Yeah,
The
but
AG
that one you
should
should
have
ask Betty Mould. You know, son.
Yeah, it's a question he poses to him, really.
Yeah, you should ask Betty Mould, or should have invited Betty Mould there. Perhaps these things would have given a new dimension to what this cut and paste relative to Woyomi is. But if my focus is on the drill ship, if you don't mind.
Yeah, we'll move there shortly. Mr. Abuchi is on the line. Let quickly just pick a point from him. Now, these findings, well, there are other aspects where Betty Mould is praised for having been expeditious in what she had to do. But this particular finding in regard to Woyomi, the commission makes a clear finding of financial loss to the state. Can the state, contemplate any such action going forward against Betty Moldudrisu?
Yeah, can you repeat it again? The state made findings against him, are you asking?
Yes, made findings of a clear finding of causing financial loss to the state in the event because of the non-failure to properly defend the state in the matter.
And you're asking
whether
the
whether or
findings-
not
yeah.
the state can contemplate, an action in court for causing financial loss against Betimo Idrisu.
Absolutely. I mean, the law on causing financial loss directs or basically grants the state and its agencies the right to, as it were, pursue anyone who has caused financial loss to the state. So, if the court has made this declaration, it represents an opening, an entry point for the state to decide to pursue any public official who might have occasioned the said financial loss caused to the state. So yes, on the face of it, the state can actually go against the offending official, so to speak.
And if the state is going to proceed on the basis of the finding of the commission, we have had a precedent where the court has said very unequivocally that the findings of the commission cannot be used to prosecute.
Correct. So that obviously represents a bar. If the state is going to proceed on the basis of the findings of the commission, then again, from the precedents that we have, yes, that represents a bar. The state will have to overcome that. The state will have to show in court that it is not relying on the findings of the committee, so to speak. But otherwise, the fact that there has been financial allocation to the state, if the state wants to go against an offending official, the state is allowed prima facie. But if the state wants to proceed at the back of a finding of the commission, those are the technical difficulties, of course, the state will have to overcome. But on the broader question of...
I wanted you to look at this little bit of it, where the state attorneys, for example, Kweku says that this is probably a rehash of the Yoko report and so on. The Judge Sapao says that the 400,000 Ghana cedis paid to the state attorneys, Nekwe Tete's wife, all of this was clear fraud, that something ought to have happened, and that it appears that there was a collusion to silently wait. They won't go to court to defend anything. Woyomi gets his default judgment, and suddenly there is a speed in wanting to pay the money to him.
The findings of the commission and the things that came up during that investigative process are things that clearly raises a lot of cause for worry. It's important for us to remember that the people who work in the Attorney General's department are supposed to be state lawyers, so to speak. Now, in this regard, whatever they do, they're supposed to ensure that they avoid conflict of interest or the perception of conflict of interest as stated under the Constitution. And so any payment made to a state attorney by a person who has an interest in the matter clearly raises very fundamental questions of conflict of interest. And as indicated by the commission, that actually amounted to fraud. What it means that the commission actually came to that conclusion. These are very, very dangerous and difficult findings that the commission may have made. And it's important. The most important thing is that it's important for us to actually overcome this or go beyond this. I'm not sure we have started even the process yet. The number of judgments that are secured against the state, in respect of which there was minimal representation or there was no representation
at all,
is enough for us to start wondering what exactly the institutional malaise is as far as that department is concerned.
Okay. Now the judge's perception, which he points out and even goes to Justice John Zoche's famous quotations and refers us to that to say it was clear from the beginning that nobody was owed anything, the state was owed nothing and ought not to have been paid. He looks at, again, the fact that at the time when the Attorney General had filed a process to set aside, the default judgment, the Attorney General fails to move that motion and rather, throws in terms of settlement agreed together with Woyomi that we are going to pay. And then only on the final day for the Attorney General to show up in court and say that, no, you know what, I was under a mistaken belief that we don't have a defense. Now I think we have a defense. So don't adopt the terms as consent judgment. And the judge refused it. Upon the refusal, the judge said, pay only one tranche and let Woyomi give an undertaking that if he loses this matter, he was going to refund the first tranche that you have paid. The state goes ahead and pays all of the money.
I'm not sure what comment you would make.
So I'm looking at the balance in the apportionment of the blame here, as far as the officers of the AG are concerned, and the AG herself, and then the judge.
Clearly, I think all these are part of the reasons why there have been calls for a restructuring of the Attorney General's Department. The Attorney General, as contemplated under the Constitution, is an officer of the government. By operation and by history, we have made the mistake of continuing the Attorney General's Department and making it synonymous with the Attorney General. So there is an Attorney General who is the Chief Legal Advisor of government, and he or she also heads a department which is supposed to be a prosecution/civil defense or prosecution department on behalf of government.
Right.
I think that moving forward and as reform, it is important for us to have an institution that is separated, a little bit separated from the Attorney General as that officer of government who performs all these functions, because that creates all these conflicts and some of the readings and the nuances and the insinuations that have been read into all these things. Because clearly speaking, the work of the Attorney General's Department is professional, technical. But the work of the Attorney General, as an Attorney General, is political government. And it's something we have to understand. Unfortunately, we don't seem to understand and appreciate that. And until we move on beyond that, I'm afraid we're going to have this replicated in the future.
Okay.
Because the interests and the dynamics are not the same.
Okay. We will certainly subject this particular report, when it becomes really official, to yet more critical scrutiny, and devote a lot of attention to it. I'm going to take a break here. We'll return very briefly, and Nana Asante will speak on behalf of Nana Akufo-Addo, who the report seeks to suggest is to blame for causing financial loss to the state. There are those who say this is mischievous. Obviously, we'll find out what exactly it is about. But, you know, in my looking at all the amounts of money that we have paid as a state to lawyers, external lawyers, solicitors in the process, I compute the over almost £3 million we have paid to solicitors. We have paid over $5.6 million to external solicitors, and we have paid over 100,000 euros to external solicitors. And I was just trying to put it together in cedis, and it gave me something in the region of close to 43 million Ghana cedis. All of it just giving to lawyers out there. We'll be right back to deal with the aspect concerning Nana Addo. You're welcome back, and this show is brought to you by Bank of Africa, strong as a group and close as a partner. Please remember to patronize Bank of Africa's very convenient banking products, and I'm talking about the electronic banking product, the B-Web and the B-Mobile, and pay your fees and utility bills also at Bank of Africa's branches all over the country, and experience the most convenient banking experience ever that you could enjoy. Well, in the nutshell, Justice Yapel says that he agrees with the Commission, with the Supreme Court, as he applauds Matanamidu for his single-handed approach to the whole process, and says, let's get the money back with interest. My question is, where's the money? That's the most important, isn't it? Very interesting. And I've got some very interesting comments. We'll share some of them in a short while. But let's deal with the aspects concerning Nana Addo Dankwa Akufo-Addo. And it concerns the GMPC, transactions as far as derivatives were concerned, or hedging was concerned, with Societe Generale, their commodities, branch. And in the end, we got to a point where they sued us. And when they sued, the GMPC also defended and filed a counterclaim, and we are told that Bindman and partners, who were our lawyers, soon after the NPP came into power, decided to dispense with their services, but never went to court to defend what we had put in court to go through the process. And in the process, a default judgment. In London too, default judgment. It's not only in Ghana that we take the default judgments. In London, a default judgment was taken against Ghana. And around this same period, GMPC and Societe Generale were actually in settlement processes in which they were agreeing. Ghana was asking them to take $10 million for their payment. And we happened to have agreed with them that they would take 14 million as final payment of the money which was in excess of 47 million or so. Unfortunately, all of that was not brought to the attention of the court, and they clandestinely, or like Jasapao said, either secretly or clandestinely, went to the court at our back. And we were not going, we had not appointed new lawyers. Nanado, who was the Attorney General, didn't go to do anything about it. And they took their judgment and got the exact amount they were actually due in the first place. So when we went and we said, we are paying you what we had agreed, the 14, they said, no, the 14 doesn't apply again. We are taking the full amount. And that is what has brought us to that judgment debt. And it makes the finding that is a clear case of causing financial loss to the state by the default in not going to represent Ghana in the court. On that one, I'll start with you, Kweku, and we have Nana Asante-Bediatu on the line. We'll speak to him to speak on behalf of Nanado.
I don't know whether government would issue a white paper on this report. That is absent. So we're waiting to hear what government will say. It's very important. Is there any evidence? And was there any evidence provided to the Judgment Debt Commission to the effect that there was a fixed firm agreement with Societe Generale for settlement of $40 million? Did the commission assess any proof that the settlement negotiations that had begun even under the Chikata management, that continued whilst the court case was still on, was a parallel thing? Did the commission assess any documentary proof that there was an agreement on 40 million? Indeed, somewhere in the report, you even see something like it says almost agreed. Huh?
Yeah.
Have you read it?
Yes, I have.
On page 67, that it was as a result of this strong defense that SG proposed a settlement while the case was pending. It is sad that while SG had almost agreed on the sum of 40 million as a full and final settlement of their claim at the time the default journal was entered, the government of Ghana, represented by the Ministry of Energy, which had wrongfully taken over the running of affairs at the GMPC, failed to bring this fact to the notice of the London court before the default judgment was entered against GMPC. Let Justice Apau and his commission produce evidence to the effect of this $4 million settlement agreement.
But they had witnesses. They're supposed to rely on them as well.
Come of it.
Chachi Chikata was there. They called as many as 11 witnesses.
Come of it. And those witnesses brought the evidence to this effect. It's still a material question. Those 11 witnesses, they brought this evidence before the court. Now, before the commission.
But in the court of law, the testimonies are also important.
But testimony will be subjected to a critical scrutiny.
Okay, please go ahead.
For its validity to be put forward. Now, I see somewhere when he talks about the encounter with Katie Hammond.
Right.
And he mentions, it's a redemption of what Katie Hammond said. And he talks of Katie Hammond talking of the SG saying that 40 million or 20 million, that is no longer their option. Yes,
because at that time they had gotten the court.
Why did Justice Apau choose to take 40 million, not the 20 million? What is the rationale for that? Yeah, he should tell us, so that he can decide to do a deduction, mathematical deduction. This is voodoo mathematics, and arrive at a financial loss to the state. But let me be honest with you, there was no such agreement anytime, anywhere. That's the first thing. And indeed, the monies that we owed SG by 1999 was $40 million. Chachuchi Carter's own memo. See it. This is his own memo, dated 15 December 1998, rather. To the board of directors, considered that we owed SG $40 million. 1998. The $7 million that came was accrued interest by 2001. That is what SG got the court to stamp on. Okay? So, to be honest with you, you know, I'm a firm advocate of the Judgment Debt Commission. I still stand by it because I think it goes beyond specifics where you can pick to say that this was poorly done or not poorly done. No, that project was a good project. I'm in principle still for it. So I'm not about to throw the baby away with the bathwater. There are a lot of things that were done that I think are in the interest of this nation. But that doesn't take away the right of scrutinizing the specifics and pointing to the omissions and the poverty of the findings that were made. After all, even the Supreme Court's rulings and decisions and judgments are subject to criticism and scrutiny. How much more a Judgment Debt Commission? You know, why, my brother? See, I read here that they have no evidence as to how the $3.5 million was disbursed or accounted for.
Yes, because they called Chris Kodo, who was the High Commissioner or Ambassador, and Katie Hammond had appeared before the commission and said that the 3.5 balance was given to him. He came to confirm that yes, indeed, a check for that amount was given to him, but he has no idea how it was disbursed, even though he confirms also that it was later taken from him by the Comptroller and Accountant General.
See, and the reference is made to Katie Hammond's, the package he presented to them. It's made, references are made to it. And it's done in such a manner that because Katie Hammond did not tell them the source, because he said he didn't know, as if it had no value. Some of the evidence they got from the Ghana International Bank were clearly, this is the document that Katie Hammond gave to the commission. In this document, which is official document, Ghana Mission in the UK, the Treasury Department, and the Comptroller and Accountant General of Ghana. This is the document. Go through this document. You will see the specific monies that were withdrawn from that account and paid GMPC for GMPC obligations. Plenty. It's here. You can check. Okay? It's all here. Did the committee take a look at that document, or they refused to take a look at it because they didn't know the source? And especially if you take a look at the evidence they got, the information they got from the Ghana International Bank, some of them are here. That alone should have alerted you to the authenticity of this document. In any case, they are maps and graphs from the Comptroller and Accountant General and the Treasury Department. These are official records. So even if you didn't know the source, it is within the remit of the committee and the commission to scrutinize it for its whatever value it came with. But if it was ignored, then I have a problem. Look, how about Nana Akufo-Addo? Why wasn't he invited? He expressed the willingness to be there, if you recall, on this very show, and then subsequently his spokesperson. Why wasn't he? Why do you make a decision that affects the man and indeed the entirety of the government? I haven't seen any specific recommendation that Nana should be surcharged or should be there's none.
There's none like that.
So I have a problem. You are the lawyer. I have a problem when I hear people say indicted. Maybe it has a different meaning. But whatever it is, at least an opportunity should have been offered him to come there. Look, let me tell you, the portion on the Dreshelpa is a repackaging of what NDC communicators, some ministers, and Chachuchi Carter had been saying and went to the commission to say. It's a repackaging. It's a recycling. No serious effort was made by the commission to deal with the issues. And I'm prepared to contest that.
Interesting. Interesting. Let me speak briefly to Nana Asante-Bediato. Nana Asante-Bediato, are you with us?
Yes, if you can hear me. Good morning.
Good morning. Thank you very much, and thanks for your patience. There are headings which are repeated, and these headings are failure of the Attorney General to appear in London court, cause of the ex parte judgment, debt, and all of that refer obviously to Nanado, who was in charge as the Attorney General at the time, and then the eventual conclusion of financial loss that's been made. Before Kweku started his submission, he spoke about whether he's unaware, he doesn't know if a white paper will be issued on this document once it is officially submitted to the president. I think that is instructive, because if a white paper is not issued, then he will not have the opportunity to go to court on the adverse findings that have been made. How does Nanado look at all of this?
All right, well, thank you very much, Samson, and let me say good morning to your panelists and to your viewers and your audience, listening audience. I'd like to begin with first principles. We have to remind ourselves that the commission is an inquisitorial commission. It is not like our normal courts, which employs the adversarial process. So the commission has a higher burden of investigating and interrogating every single issue that comes up and looking for evidence in support of one particular fact or another. I think that in this particular instance, the commission has failed in that endeavor. Now, what was the commission's remit? To ascertain the cause of inordinate judgment payments, to ascertain whether financial losses have been caused, and make recommendations in respect of all of these. Now, from what I have seen of the report, there is nothing really about the actual cause of this debt, which is the original GMPC debt to SG and how it came about and so on. So there's a big lacuna there, and I don't understand that. Now, let me also say that we have written formally to the Commission, copied the Chief of Staff at the Presidency for an official copy, because as someone said the other day, we're not sure whether even what is floating around is it. But I'm willing to, I've just heard Kweku Baku say that he has a legitimate copy, and I'm prepared to accept that. There is a legitimate copy there. Now, first of all, as Kweku has already noted, and I won't belabor a lot of points because I think Kweku has made an adequate submission on some of these things. But it is important that even if you're an inquisitorial commission, a person's right to be heard should never be taken away. Now, also clear, there's a lot of innuendo in the report, which I find quite unfortunate, because talk about the Attorney General. You can talk about the Attorney General as an institution, and you can talk about the Attorney General as a person. It seems to me that it doesn't directly name Akufo-Addo, but gives enough innuendo that any person reading the report will obviously attach the Attorney General to a person, Akufo-Addo. I think that's also unfortunate, because he mentions other people's names directly and not their offices, like KT Hammond and so on. So I think that's also a difficulty. Now, if they had called Akufo-Addo, perhaps the issue, for example, about why he didn't go to the London court, which is an issue of discretion in the Attorney General to decide whether to contest or not, would have been adequately explained to him. And I think that, as a matter of first principles, the denial of the right to be heard makes some bit of nonsense of the report. Now, it is also clear to us that it is not as though the Commission had documents or correspondence that made Akufo-Addo's presence unnecessary. He does not say so. Documents or correspondence in his own hand that clearly he could then make some of these findings on, even if he chose not to invite him. So the report suffers from a huge deficit. And just to digress a little, you just spoke about the white paper, and if a white paper is not issued, then Akufo-Addo cannot go to court. I think as a constitutional matter, I would have to disagree with that, because every person under the Constitution has a right of access to the courts, especially when his human rights are concerned, especially when we're talking about the rights of natural justice. And here we cannot allow a report to be hanging, and government chooses not to issue a white paper, so that the issues in the report become issues of fact that people can talk about, and use it to assail a Akufo-Addo. I think that is wrong.
Nana, I'd like to thank you very much for your time. Unfortunately, we have run out of time. We've just been trying to see if we could get just a minute or two to add on, because Yunus Afseni and others want to make at least a comment each before we can move on. But we should find the platform.
If I may make just one last point, I just want to say that if indeed this report about Akufo-Addo is to attack his incorruptibility, I think it is futile. And I think people should stop trying to do that. There is nothing in Akufo-Addo's background, his professional work, that will suggest corruption. And they should just give up. It will not fly.
I see. Very interesting. But very quickly, maybe just in a minute. Yes.
First of all, let me say that even though Mr. Malik Abdul says that there was no agreement of 40 million, let me say that as a lawyer and as somebody who clearly knows that it's possible in law to accept a smaller amount of money in satisfaction of a larger debt. And that is evidence in what even happened under Katie Hammond's engagement and negotiations. Now we know that the sum was 47 million, but Katie Hammond paid 19.5 million. It means that the people were amenable to negotiations. That's what it means, clearly. This particular matter, I mean, the matter of the documents that were submitted by the Katie Hammond raised issues of custody. But even then, the commission referred to them. That was how the commission. That was how
I suppose we should have more time. Yes, we should, but unfortunately we don't have. I apologize.
He referred to them, but did not rely on them.
Right.
As an extension.
But so I apologize. What I can assure you is that we'll find another time and complete this discussion. I think that's the best way to go. Thank you very much, Honorable Yunus Afseni, Tony Forsing, and then Kwaku Bako Jr., and also Ernest Kofi Abochi, as well as Nana Asante Bediecho. I'm Samson Ladia Yanini. We have run out of time. I'm sorry. We'll be able to get to you next time. Very interesting comments from all over. Esankoma has very interesting perspective on this issue. We'll deal with all of these subsequently. Thank you very much.